position that human rights should be regarded as more sacred than economic rights. So, Jack, why don't you read the statement?
We want to start by just thanking you, Mr. Inglis, and everyone for taking the time to be here today. We really appreciate it. As each week ushers forth a new NSA scandal, each one more egregious than the last, we cannot help but recall the wise words of a local favorite, Benjamin Franklin, who once said that those who would trade liberty for security deserve neither. One can only wonder what Franklin would think if he were here today to witness this unprecedented erosion of privacy that has occurred under the NSA security regime. The scope of the NSA spying program is truly terrifying, and the NSA has resisted transparency by engaging in a persistent pattern of deception. As recently as August, the NSA's legal counsel dismissed claims that the agency was spying on public figures. Now, however, we know that the NSA was operating such a surveillance program, stirring international outrage that's ongoing. More alarmingly, the NSA was misleading the public by claiming that a valid court had authorized every invasion of personal privacy. By your agency's own admissions, however, there have been several blatant abuses of power, including analysts using their access to privileged information to spy on ex-girlfriends. Beyond these bad apples, though, the deliberate lack of transparency within the FISA court framework structurally produces a system that is ripe for abuse. Earlier this week, the inherent unaccountability of the FISA courts came to light as a declassified opinion by FISA Judge John Bates voiced concerns that the NSA could not function within the rule of law. The truth about exactly what data the NSA is collecting is still ambiguous. Former NSA analysts have alleged that the specific word-for-word content of all electronic communications are being collected on a scope far beyond mere metadata. These claims are substantiated by the quiet construction of your agency's 100,000 square foot data center located in Bluffdale, Utah, which former NSA official William Benny pointed out could collect over 100 years worth of communications. These facts suggest that the content of every single communication is being seized and stored by the NSA. In light of these revelations, we demand that the NSA cease all illegal spying programs. More specifically, it must halt the blanket telephone and internet surveillance instituted under Section 215 of the USA Patriot Act and the FISA Amendments Act. As a critical precursor for restoring the public's trust, we also strongly urge the NSA to transition from a reliance on the FISA court system to a more transparent judicial process. Further, the NSA should publish all secret legal decisions and details on all surveillance programs, so whistleblowers, like Edwards noted, don't have to risk their livelihoods to keep the public informed. In short, we do not feel the blanket justification of an endless war on terror justifies the unprecedented expansion of surveillance powers. The stakes are high, as our personal privacy protections are under constant assault. The leaders who implemented these programs must be held accountable. Until the surveillance state ends, the NSA spying programs will continue to be a major threat to our national security and welfare. The time to begin restoring our constitutional liberties is long overdue. How do you plan to address these serious constitutional grievances?
Thank you, and I'd like to